including working in Meta as a privacy counsel. I, lended my experience, expertise to starting the Association of Privacy Lawyers in Africa, because I believe that lawyers play such a role in making sure that Africa is also level set with other counterparts in this area. I'm a mom, I'm a wife, I have my own law firm, my own law practice, and I'm excited to be here.
Wow, thank you so much. And this is why we are saying that our panel brings together Africa's leading voices, and each of them are a champion in their own right within the privacy aspect. Now, just to start off with you, Igxtelle, while you still have the floor, but this question will be for everyone. I want us to look at the advocacy advantage and why we will have the opinion, or why one will have an opinion to say it matters for DPOs. So the question will be, how do you see the role of advocacy in advancing data protection and privacy across Africa? And while you're still on that, you also include any unique opportunities or challenges that are represented or presented by data protection professionals on the continent. And as you answer this, please do walk us through your journey in line of your experience.
Sure. So, what's the role of advocacy? I mean, I would like to start answering that question by just simplifying. When we talk about advocacy, what exactly is it? From my understanding, it is simply telling the story in the best way that you understand, conveying the message to another person so they get the vision, they get the why, they get the how, and they catch the fire. Now, advocacy is very important because before we have a revival, and I'll use this term because it's not just a term that we use in a religious notion. Before there is a revival of anything, there has to be groundwork that goes about on what that thing is. Why is it important? Advocacy in the data privacy space is important. Why? Because data is our future. We've moved into a new realm that those that lived in the 90s and in the 80s and in the 70s and even the early 20s did not experience. And this is not going to change. This is not going to shift. Data is becoming a currency. It will become more and more the currency that we see now and even more in the future. Advocacy for a DPO is extremely important because for you to occupy that space, it means you understand what I just said. That data is our new currency. Now, how do we protect it? How do we leverage it? How do we make sure that our governments have the same understanding? How do we ensure that people, you and I, the everyday person who is either not a lawyer, who is either not a technologist, who is either not into cyber space or crime or artificial intelligence, how do we make sure that they also get the picture? We will have to find a way to tell stories. From my personal experience, I say, just putting out there where we are, telling stories by, letting companies know, governments know, individuals know that we have moved into a new realm. We can see it on social media, we can see it on the different apps that we're all interacting on. And that is the best way as a DPO that we start telling stories. We find a good way to tell the story we best understand in a way that people will best understand it in their language.
Thank you so much. I think one key takeaway there is data is our future and data is becoming our currency. Dr. Mugambi, anything you will want to chip on that as well?
Okay. I think like I can talk about us as a society. How do we do this advocacy? If you look at like our last year's report, there are several things that we do on these issues of advocacy. One of it is litigation. That data protection being a new space, there's a lot of resistance, especially from the state and government. So sometimes we do submissions, for example, to parliament or to ministries, and they don't listen. So this pushes us to be involved in litigation. So we have, at the Data Privacy and Governance Society, we have involved as interested party in 4 different litigations. One of it being this petition challenging the constitutionality of the Data Protection Act. There's another one challenging the constitution, challenging the powers of the Data Commissioner as structured in the Data Protection Act. We have another petition where we are challenging the Communication Authority of Kenya and the Kenya Revenue Authority, where they want to collect IMEI numbers of mobile phones. So that's an issue to deal with surveillance. And then we're also an interested party in another matter that relates to challenging the processing of digital health data. So this kind of advocacy, what it does is that we are able to present the professional's view about implementation or execution of the Data Protection Act, Article 31, on the right to privacy. So for us, litigation is important. But also, secondly, is the engagements that we have with the regulators. For us, we have constant engagement with the Office of the Data Protection Commissioner, where we present our views on draft guidance notice, draft regulations, and also telling the regulator what challenges professionals are facing and how we wish them to be addressed. So this is the kind of, including what Igxtelle has said, this is some of the things that we do as a society in Kenya in
Thank
terms of
you.
advocacy. Yeah.
Yes. So I believe I will be correct to also note from what you just noted that as a DPO, you are not only an advocate of privacy, but you're an advocate of the data subjects as well.
Yeah, that's correct. And maybe just to mention, because you see, our society is called Data Privacy and Governance Society. So it's not just about data protection. It's also about data governance. Because if you're talking about protection of data, you have to also to think about the principles of data governance. So we're also looking at the life cycle of data. We are looking at as a society, as you see, we have representation for public, private sector, not for profit. We have techies, we have lawyers, all manner of professionals. So we are looking at the whole 360 view of data protection, privacy, data governance, tech, and the things that we do. So one of the advantages in being in this forum of Data Privacy and Governance Society is that we're able to get the views. For example, the Data Protection Act in Kenya will not be there without civil society. It's civil society that really pushed, and we got the Data Protection Act. They went to court, they petitioned, they drafted bills, and we are here. So we always ensure that as a DPO, one of the things and the platform that we offer as a society is that you're able to interact with people from different facets of digital rights, different facets of data governance, public sector, private sector. And that's what helps a DPO, whether you're an internal and external DPO, getting these perspectives usually give a good opportunity that now you can also think about how do we protect data subject, but also important, you need to protect the business of the data controller and data processor, because it's not a war against data controllers, data processor. It's providing a mechanism for them to comply with the law, meet their bottom line, make their profits, but also comply with the prevailing rules and regulations.
Indeed. Olumide, allow me to also cue you in there as well. What are your thoughts on that?
Both Igxtelle and Mugambi, they've spoken to the whole issues around advocacy. As DPOs, I understand some of DPOs might be in-house, so there might be a limit to the things they can do with rehabilitation. Almost everyone can do is to write. We all have digital platforms. We all have access to some blogs that we can write on. And when we see regulators come up with all sorts of guidelines, all sorts of regulations or laws, the best we can do, or the easiest we can do to make our voices heard, is to write about these things, is to critique it, is to advise on how better the regulations could come out. In our own case in Nigeria, sometimes they come up with this documentation and we are able to send in suggestions, but sometimes they don't. But even when they did not, we went to the public and we depreciated that kind of practice, because if you are coming out with any legislation that will affect the public, then it should be made public so that you can get public consultation, you can get public opinions on this thing. So the easiest thing for DPOs, whether external, whether internal, is to write on existing laws, on proposed laws, on activities of the regulators. In our own case, we've had to complain about categorization of data controllers. We've had to complain about registration of processors. And to some extent, the regulators, they heard. Whether they 100% change their position is another thing, but at least they heard what the industry was saying. And so if we can, I mean, in my own case, I go to court. I mean, I can easily file an action in court and hear what the court would say about it. In some cases, we do events where we allow people to come and share their opinions about these issues. But these are the ways to go about advocacy. Either you go on social media to either rant in your own way, and somehow these things get to the regulators. It gets to them. Either you speak out in your own way, or you write an article, or you critique whatever they have come up with, or you make suggestions about whatever they have done. And then these are ways in which we can all improve the ecosystem. And in our own case too, we organize events. And we invite the regulators to also come and speak. And sometimes it gives us an opportunity to be able to ask them questions directly, and also for them to know what we feel about these things. We do roundtables, we do workshops, where we invite them also to come and speak. And sometimes we do visit them and tell them, okay, this is what we do. But most importantly, policy change could come in any form, or could come as a response to any form of agitation, either social media, either litigation, either articles, or even writing the regulators directly and letting them know. So that's what I feel about advocacy.
All right, thank you so much. What we got here, our wonderful audience, is that as a data protection officer, you should go above just interpreting the laws for compliance. Be an advocate, because data is becoming our currency, and I love that. So, to our wonderful audience, if you have any questions so far, do cue them into the chat. We will get back to them as well. And also, if you are just joining in, please do know the country that you're joining from, or the African country that you are from, and also leave in your LinkedIn URL so that we can connect with you. Now, back to you, Dr. Mugambi. I want us to look at how we can bring laws into action. How can we bridging policy and practice? So you have been instrumental, I must say, in shaping privacy legislation and training legal professionals. What are the biggest challenges that data protection officers face in translating policy into practical day-to-day compliance? So, and also, how can then advocates help to bridge this gap?
All right. So on this, I would like to provide, a very objective analysis about these challenges. So, as the Data Privacy and Governance Society, every year for the last 2 years, we've carried out a survey, and I'll share the link, surveys of the DPOs, to just get a feel, what challenges are they facing, what is the environment. So in 2023, in 2023, 2024, we did a survey. I just want to mention what are some of the issues that DPOs in Kenya are saying that they are facing. So one of it, of course, is the issue of resources. And that you find the organizations, whether in the public or private sector, that don't have insufficient resources, limited budgets relating to staff, tools to perform the DPO functions, to carry audits, etc. Then the issue of lack of organization of buying. You see, the law is there, but to translate it, you need, for example, like today in the morning, I was doing a session with not-for-profit organizations in Kenya, where I was doing a presentation and explained that if you don't have the highest decision-making organ of your organization saying that you are going to carry out a privacy program, then it doesn't work. Something else, of course, is ambiguous legal requirements. And I think I like that Babalola has mentioned that sometimes you have to tell these regulators and these policymakers that you can't translate something that is ambiguous. And for us as a society, we towards the end of last year, we even did a bill and shared the bill with the Office of the Data Protection Commissioner and shared it with the Ministry of ICT, saying, as professionals, these are the gaps we are facing, and this is what we want. This is what we want. These are the changes we want to see in the law. Something else members have mentioned, of course, is the issue of law awareness. And law awareness, this is that people have said that data protection is a very city thing. So if you go outside the city, for example, if you're in Kenya, you go outside Nairobi and you go to smaller cities, smaller town, this is not something that they really appreciate. But the Office of the Data Protection Commission has been trying to carry out initiatives to take data protection compliance out of the city. Then something else, of course, is people getting to appreciate the role of a DPO. So you'll find that in our surveys, we find that DPOs are paid. They are paid like low-level entry employees. Well, somebody is helping compliance and handling a lot of data, personal data for an organization. So that is definitely another challenge. Another challenge that members have talked about is a lot of data controllers and data processors just want to implement technology without having doing the due diligence, doing DPIA. So long as the chief technology officer or the ICT managers approve these, then the issues of doing DPIA becomes a problem. So these are some of the, of course, also opportunities for training. You find that it's also quite prohibitive, especially for a lot of our young members. More than 60% of the members from the Data Privacy and Governance Society of Kenya are below 30 years. So they don't have resources to carry out this training, to get certification. I mean, official certification. They can go to trainings that are not at any cost, but now to get those international recognized certification like PCB, IAPP, then it becomes prohibitive. So how do we bridge this gap? I think one of the gaps, I mean, is like what has been mentioned is that one, of course, the development of sector-specific toolkits. For us as a society, for example, we develop frequently asked questions for DPOs. So if you go to our website, you'll find FAQs for DPOs that if you wish to carry out the role of an external or an internal DPOs, what are some of the aspects of the organization that you need to pay attention to so that you don't get into the role blindly. Then secondly, something else that is very important is that engagement with the regulator. And I've said for us, we have very close collaboration with the regulator in terms of unpacking policies. For example, a few weeks ago, we had officers from the Office of the Data Protection Commissioner taking us through data protection impact assessment. So from their view, how do they expect us to carry out data protection impact assessment? Last year, we had them take our members through the issue of carrying out data protection compliance audits. So that collaboration helps us deal with these challenges, especially on issues of translating the policy into action. Then another challenge, we find that more than 60% of our members are lawyers, and as lawyers, our appreciation of technology is quite low. So it's also the need to appreciate how technology functions. I think the DPOs who are lawyers know this, where you have to interact with the IT department, and they're like, you lawyers have no idea how technology works. So like for us as a society, bringing together, we have IT specialists, we have data governance specialists. It helps us appreciate these other roles within the organization, because we know that as a DPO, you cannot exist in a silo. So these peer-to-peer networks are very critical, are very important. And like, for example, with Babalola, with Igxtelle, we've planned this where you get people to come and speak from around the continent, from different professional backgrounds, so we can appreciate the different nuances of data protection practice. I think I can stop that for now and wait for another question. But I hope that gives you a clear picture of some of the things that we are trying to jumpstart around here in Kenya.
It does, truly. And we have a lot of people here in the audience from Kenya. So I look forward to as well to them just noting some of the challenges that you guys are facing in Kenya and other African countries. What are the challenges that you are facing as a DPO, and how would you want to be assisted? And I think the most critical thing that I was able to pick from you was that of peer-to-peer networking. We have to collaborate, and they always say no man is an island. And this is something that is new for most African countries. So let's find a way to collaborate. I love that. Now, I want to cue you in, Olumide, to say that you have litigated a landmark privacy cases, and you have led advocacy initiatives such as PrivCon and DRLI. Now, how can DPOs, based on your experience, effectively contribute to policy development or legal reforms in their countries? And just chip in as well to also note the practical steps that we can take. And I'm saying we as also part of the DPO. Yes, I believe your mic is still off.
Sorry,
Yes,
sorry.
wonderful.
Thank you for that. So, I mean, this takes me back to what I said earlier. So, yes, I understand sometimes the inhibitions that DPOs could have because they are in-house, but easily they can participate in policy considerations. Um, sometimes there are invitations from the regulators for people to make recommendations around whatever policies they are releasing. I've seen in the past in Nigeria, sometimes they want to come. Now, recently, the regulator issued what they call guide in Nigeria, for example, and the guide is an explanation of the extant Nigerian Data Protection Act. That would have been an opportunity for DPOs to express their opinion on how these things will really work in practice. Because there are certain provisions of that guide, so to speak, that really do not answer the real life questions that DPOs would face in practice. And we can talk as professionals, we can talk as litigators, but we are not really the ones who experience these problems firsthand.
Yes.
DPO is the one who will be answering questions around data subject access request. A DPO is the one who will be answering questions around rectification, for example. They are the ones who have first-hand experience of these requests by data subjects. And they are the ones who can really know how best it is for them to be able to fulfill their obligations around it. So when they see documents from the regulators, they are in the best position to make impute, whether the documents have been released or whether they are even draft. For example, while working, once they encounter certain problems, they should be able to write to the regulators and say, oh, this is the particular problem we have, and this is what we think is the best way to be able to handle it. Or even task the regulators to be able to provide, the DPA, to be able to provide answers to some of these problems. And of course, DPOs in Africa are now ripe to begin to congregate themselves, to begin to have forums, to begin to have convergence, to begin to have meetings, to begin to have roundtables around real life issues that they experience. So, I mean, data protection in Africa is now about 15 years, or even, sorry, more than that. 2020, 2001, I think Cape Verde, 2001 is, yes, 14 years now. So we can say we have come of age to begin to have this convergence. Then they should be able to engage with professional associations. In Kenya, Mugambi started something fantastic. In Nigeria, we've started something as well. I mean, these are opportunities for DPOs to be able to even build the ecosystem, because they are really the ones who have experience in this field. They are the ones who have first-hand experience. And also, there should be a platform where they can share case studies. The IAPP does that, and it is very, very impressive. They have this thread where DPOs, professionals who have real life problems, they come to such platforms and they ask questions that, oh, this is what I'm facing right now. How do you think is the best way to solve it? And people are able to give real life answers to those questions. Most importantly, our regulators, our DPAs should have regular meetings or regular sessions with DPOs.
Yes.
And it's only when DPOs task them that they can easily do this. And lastly, DPOs should be at the forefront of harmonizing the irregularities in our laws. They should be at the forefront. For example, the way there is no clarity yet, from my point of view, on child consent in Nigeria. There is no clarity yet. How is it best approached? What is the age we're talking about? Now we have in the substantive legislation, we have two different ages. We're looking at 16, is it 16 or 18? And we're looking at 13. But it is people in practice that can actually speak to this. Also, an issue which we can easily learn from the Kenyan perspective, which other countries DPO can drive, is sensitive data. I always say that all the time. The Kenyan legislation has financial details, has family details, has sensitive data. The Nigerian counterpart does not have it. It is not in our laws. So, and it is ridiculous that in Africa we are following hook, line, and sinker what the Europeans see as sensitive data. For example, I imagine a TPO in the financial sector in Nigeria should have tasked the regulator that come from where we sit. And I'm happy Olatipupo is on this call. He's one of the executive members of the association we have in Nigeria.
Yes.
We discussed sensitive data from the Nigerian perspective. I see the Nigerian regulator, the Nigerian CBN, the Nigerian Central Bank, in one of the documents they released around open banking. They are dancing around whether financial details are sensitive data. But our law of the Nigerian Data Protection Act does not recognize that as sensitive data. So I think this will be a fantastic opportunity for someone in the financial sector who is a DPO to come up with a position paper, or to even come up with an article, or to come up with a write-up to the regulator. Because under the Nigerian law, there is the provision for the regulator to designate further data as sensitive data. So if a DPO in that field writes to the regulator will take it more seriously than us, who they readily see as troublemakers. If we say anything about that, they will just say we are doing our routine troublemaking. But if somebody in that field, a DPO, writes them and tells them, come, we are in the field, and from where we sit, this thing is sensitive data, I think it will make more sense, and they will give it more attention than just a generic advocate writing them for that. Thank you again for this interesting discourse.
Thank you. But while you're still on that as well, I'm very much now interested in knowing, are there any cases that you are willing to share with us, and how you have uncovered these cases where now you are championing and also not trying to translate and making a change to say DPOs, you are change agents, and be at the forefront? Because the reason why I'm asking this is that many on the call here may have experienced privacy harm and may be interested in having their voices heard or unsure how to navigate. So, are there any particular cases that you will say you have championed, and how were you able to uncover those to assist those whose rights have been infringed?
Oh, thank you. So, so the approach will be different per country.
Yes.
I have not had the opportunity of reading all the African laws, but I know some people, the regulators might be stronger than each other. And because of the number in Nigeria, I wouldn't honestly blame the regulator in terms of the number, because we have numbers and people, I can imagine if they get so many petitions or so many requests, they might not have the capacity to be able to handle all of them. But in Nigeria, we have always approached the courts. We might write to the regulator, but we'll go to court, and we're able to ventilate some of these issues. Yes, we've had situations where people's financial data have been mismanaged or misused or exposed. And yes, we've been able to some extent, get reprieve from the court. So there are a couple of cases I have shared, even on my LinkedIn handle. There was one that Olatipopo handled himself, but it has to do with unsolicited messages from a food vendor. And in some cases, I have also handled one where that involved the banking sector. So the approaches have always been different. But again, for a DPO, I would always advise, for a DPO, I would most likely always advise an approach to the regulators first, because they are in-house. And that might be a cheaper option for them to always at least approach the regulator, depending on how strong the regulator is in the country. And subsequently, they can now approach the court for reprieve. But I mean, cases passed in Nigeria.
Yes. No, we also look forward to also, getting sight of the many cases that she will handle in future. As he did mention, do follow him on his LinkedIn to also have preview of the cases that he will be sharing, just so we help each other in this everyday task that we are doing as DPOs. To everyone on the call, our wonderful audience, if you have a question, just note it in the chat and we will get back to you. If you're just joining in now, please do note the country that you're joining us from, and do note your LinkedIn URL in the event that you will want us to connect with you. This is collaboration, this is peer-to-peer networking, and at DPO Africa Network, we are all for that. Igxtelle, I want to bring you in, as well. You have built frameworks for child online protection, and led privacy programs at a global stage. Now my question will be, what are the most effective ways that data protection officers and advocates can raise awareness and build a privacy first culture within organizations and communities?
Thank you for that question. And also, I just really want to say to the other panelists that enjoy listening to you, gentlemen. You're all a wealth of information. I always learn every time I'm in discussions involving the both of you, and you light the fire. But not just me, I think for all data protection officers, in Africa. So, with regards to child online protection in Cameroon and the work that I did, very similar. And I'll just tell the story because I believe with stories, you really will get the point. Um, in Cameroon, a law was passed about, I think, July of 2023 on child online protection. And the agency that was put in charge to ensure the enforcement of that law was notified. But this was just sitting in their dockets. No policies were built or made or created towards the enforcement. The stakeholders, other partners, ministries that had to do or put up some kind of reform to ensure the enforcement of that law were not doing anything or didn't have any knowledge about it. Parents, children, schools. We're talking about child online protection, and there was no activity. Excuse me, guys, my daughter is here. Louis, I'm talking.
Oh, that's fine.
Say hi.
Do you saying hi from the network?
Good morning. All right. So, what I had to do then was reach out to the agency that had the task to implement that law and say, this is who I am. I'm an attorney from the US. I've worked on similar things in a different jurisdiction. Give me the opportunity to take the law and break it down into actionable steps. Let us identify what tools will be needed to implement this law. Let us identify the teams that will be you need to come together, the different technologies, the stakeholders. Let's do a training. And so all of summer of 2024, that's what I did. I took that law, broke it down into actionable steps. Here is the definition. And for sure, there were a lot of gaps that were identified. The same issue that you bring up, Babalola, on the age of consent. Is it 18? Is it 13? Is it 21? At what point in time, and what really is parental consent when it comes to a child? If we call their parent and the parent says yes, is that okay? Is it supposed to be written? And the law did not specify that, leaving gray areas for us to reach out back to the Ministry of Telecommunication and say we're identifying a lot of gaps in these areas. The work that I did was break down into actionable steps to that particular authority and say, here is what you need to do. Now, in Africa, regulators or enforcement agencies really want to see what is in it for them. That is the culture in most countries. I cannot speak for the entire continent, but then our role as a DPO My role in that case was to show them here is an important cause. Children are getting cyberbullied. There's a lot of trafficking and a lot of ills that are on the internet that parents may not have the ability to step ahead of because technology is advancing and it's a generation skip away. But as a regulator, as an enforcer, here's where you come in. Make sure that the people understand what their rights are. Here's what the law prescribes. And here are the tools. We need a reporting tool. We need to be able to talk with our telecommunication agencies and say, can we have some kind of reporting where if cyber crime is happening or cyberbullying is happening or something is going on with a child's data, they can report it to this area, and building the teams to a point where they are able, number one, to know the law for themselves. I'm talking about the regulators team. Know the laws for themselves, know the stakeholders, and know also what it means to enforce. What is compliance? What is the standard? And when do we know that the standard is not being met? I think, that was still a work in progress with that. The training happened. The regulators team knows, the stakeholders are aware of what needs to be done, but there's still a difficulty of, the right resources, the tools, the teams to go out there, continuous sensitization on child online protection, continuous involvement of the tools in that space, and continuous training for those that are, interested in building, for example, a career. And I want to just say this, and it is to Olumide's point, that I think Africa is ripe to have forums where we start having these discussions because we have enough evidence, enough data, enough things that have happened where DPOs can get together in a forum and just say, this is what's happening in my jurisdiction. How do I handle this? And that's why, the Association of Privacy Lawyer, which, I started a couple of years ago, that, all you gentlemen are familiar with, plays a very, vital role, because we've set up that platform where lawyers can come together and say, here's what I'm dealing with. Can Kenya tell us how you've dealt with this so that we can best educate Cameroon what it would take for us to come up to par, because we're not all at the same level. Other countries like Mauritius, Kenya, Ghana, Nigeria, they're doing quite great work. And so we want to be able to handhold each other as DPOs, as lawyers, as advocates, to make sure that we're all moving at the same level. I know I've said a lot of things. I hope I've answered the question in some way or fashion.
You have, and thoroughly so as well. But I also want to bring in my other, my wonderful panelists as well to just chip in on that, particularly just sharing the successful awareness campaigns or strategies from your experience when it comes to dealing with this issue.
Okay. All right. I can start. So, like for us, and maybe just to chip in with the question that's there, I think I saw a question on the chat that relates to IT and legal collaboration. I stated, like for us as a society, one of the things that we did, we approached the data commissioner and told the commissioner that we need what we call mentorship sessions, where the commissioner can come and unpack some of the practice areas. And when we were dealing with the DPIA, the commission brought a lawyer and a techie. So we were able to get the perspective of a techie relating to data protection and the perspective of a lawyer relating to data protection. So that cross-professional collaboration becomes very good. Recently, actually this week on Tuesday, we had what we call a mentorship session that was on data governance. A lot of us, our DPOs are mostly fixated on data protection, but we had one of our members who took us through about the basics of data governance, and we were able to appreciate the role of the role and the value of data within an organization, whether it's personal data or non-personal data. And to us, that's quite a huge success. Something else that we do that is really critical is that we have what we call one-to-one mentorship. So under our society, we have around 10 members who are 10 members who have volunteered to be mentors, and they're mentoring around 14 young professionals on how to practice as a DPO, whether internal or external. And these are techies, some are lawyers, some are marketers, because within our society, we have all this. We have marketers, we have accountants, we have techies. So that becomes very important. And lastly, something that we are doing, especially for the future, we have a chapter at the University of Nairobi called Data Privacy and Governance Students Association. Last year, that association, we mentored them to carry out an essay competition. The essay competition was on the challenges of data protection, and it attracted 40 entrants for university students. So what that does is that we are creating a new generation of data governance specialists who now get to appreciate and understand, so that by the time they graduate from university and get into the market, they're not green, and they have an idea that this is a new area of practice. These are the challenges. These are the professionals. These are the professionals can mentor them. And for us, these are some of the success stories, in just over 2.5 years of existence, that we're able to mention that have provided real value to our members.
Amazing work. Olumide, will you want to chip on that as well?
Currently, our work is majorly now around the new association that we have founded. I mean, it's a platform that now enables many professionals to come together and see as much as we can do. I mean, because we just started BO work in March or April, so we've not really done so much. But in terms of sensitization, we've had like 2 webinars and 1 workshop. And one of them was even on the CBN's plan around open banking. Open banking, as important and as interesting as it is, it exposes us to a whole lot of privacy risks and data protection concerns, especially as it relates to access to personal data, relating to customers' consent where required, and even the entire framework. We're looking at it, and we even internally we're discussing if we should soup on it. And there are also other issues that have also been attracting our attention. And with respect to collaboration, like I said earlier, we are currently collaborating with Mugambi's team and his association as well to be able to host a webinar. We're also collaborating with the unwanted witness in Uganda, which is, I mean, I'm so big on collaboration, especially cross-border collaboration. That's how we can grow as a continent, because we can share ideas, we can have cross-pollination of ideas based on different approaches from different countries. So in November, we're hosting a conference, also privacy, the privacy symposium, Africa, and we're hosting in Lagos, and it's also an opportunity for us to collaborate with professionals from other parts of the continent. So that's basically what we're doing right now.
Indeed. And I think I've been able to pick, though we are from different African states here, I think I'm able to now bring it down to say we are facing more or less the same problems or challenges, from the lack of resources to ambiguous laws or regulations in between, from data protection to the other regulation that has already been existing. And the main thing here, and I believe for the audience as well, you make you into the chat as well, is as a DPO, know the laws, like our panelists have mentioned, know what it means to comply, engage the regulator, and be an advocate of data protection. And I think I will also be doing justice in stating that as a DPO, you need to be continuously learning. And one of the things that we are doing here at DPO Africa Network is not only to bring these webinars where we are now sharing and collaborating and also sharing insights of what we are doing in the countries that we are in, but we are also even providing our courses. And now we also have an upcoming course, which is the Data Protection Foundation course. And this is one course that I have taken as part of this network. I 100% recommend it to everyone within the audience who has not yet had an opportunity to take it. And it has had a lot of great reviews, 5 stars across the board. This course is focused on operationalizing data protection targeted at aspiring as well as practicing DPOs. So the broad sentiment is that this is more of a foundational course. We don't want you to miss out on this opportunity. And Amaka will share in the link for you to register. And we look forward to having you with that as well on the course. We are also launching a data protection practitioner course, and that will be building up on the DPP course, which is the one that Amaka will be sending the link through. So that if you are interested in operationalizing data protection and privacy programs in your organization, this one is exactly for you. It's a 6-day course, 2-hour live classes, and all classes are recorded. And both of these courses, Amaka will share the link for both of them. So do register, and I look forward to seeing you on the class. Now, to bring it back to my wonderful panelist, I want us to look into the issue. You guys have been touching on it, though I hadn't asked as of yet. I want us to talk about cross-border collaboration, learning from each other. Just as a quick round, what's one lesson or best practice from your advocacy work that data protection officers across Africa should adopt to strengthen cross-border data protection and collaboration? Any one of you can start. I'll just give you guys just 1 minute on it.
Yes, I think I spoke to that earlier on. So
Yes.
uh, um, there would always be opportunities. I mean, it's good that we see what's happening across Africa now. A few organizations springing up all over. We can help. We can work together and see. I mean, harnessing our strength. So while some people might be good with resources, some people might be good with pursuing funding, some people might be good with pursuing resource persons, and also what is obtainable in those jurisdictions with respect to either the regulation or the enforcement of data protection. And there are so many ideas that we can learn from each other. And also, because I mean, data protection in Europe is practiced as a block. That's where you see within the European Union, or I mean, even the GDPR itself was introduced to harmonize the entire data protection landscape in that region. So Africa should also be thinking about that. If the regulators are not really taking initiative, then the practitioners can start. And there we can also advise the regulators on the best approaches to some of these things, especially the relatable approaches that other African countries have taken and that can work in. Because I would really like to see a situation where Nigeria will quickly tweak its understanding of sensitive personal data. It's not working for me. It really doesn't really make sense that what we call sensitive in Europe is the same thing we are replicating in Africa. And that makes it difficult for us to even be able to litigate some of these things, because they say, oh, come on, by the provision of the law, this is not really a sensitive data. But I mean, in reality, we know that some of these data are sensitive. And if the regulators are not thinking in that regard, if professionals can come together and they can form a block, then most likely the regulators will begin to listen uh, uh, to such agitation. Thank you once again. Thank you.
Thank you. Mugambi, doctor, anything?
I think Babalola said it all. I think same thoughts.
Indeed. Ixtel?
To all the organizations that are represented here, the Association of Privacy Lawyers in Africa is open for collaboration. We have webinars that we host teaching the legal professionals on that. We're collaborating with ACDT out of Ghana, and we have an upcoming event. We're reaching out to different jurisdictions to do the same thing we did in Cameroon, which is lay out their child online protection laws and train the regulator staff, as well as set up frameworks that they need. So collaboration is really the only way to go, and that's why this webinar, I'm very grateful to Amaka for inviting and pulling me in, because again, it goes ahead to show that we're really not in this space to try to make a name for ourselves as much as we are really trying to make sure that our continent is developed, is protected, and we're moving forward. So we're open, would accept invitations, and would extend invitations to collaborate as well.
All right, the audience, that is for you. And Ixtel, Thank you for gracing us with your presence as well. I think it's better that I'd also note that. Now, before we move on to addressing the Q&A, we have a lot of questions on the chat. We do have one quiz for you, our audience. Remember, I mentioned that there is a prize that you get. This is just on the poll there. The question is, the mission of the DPO Africa Network is to build dash of data protection professionals driving collaboration, innovation, and excellence in privacy practices across the continent. Which phrase correctly fills the blank? You do have 14, let's say 40 seconds for you guys to answer. So just fill in the poll and then the results will speak for themselves and then we'll be able to pick our winner. Audience, this is for you. All right, the time is up, and A is the correct answer. And I see most of our audience got that correct, 56%. And looking at the poll leaderboard, our first winner in just 28 seconds is Princess Motlogela from Botswana. Congratulations. We also have Yasmin is our second comer up, and Chiremi as our third. So do send us an email, Princess, to info@dpoafrica.net to redeem your pass. And just to go back to the Q&A, there are a lot of questions for you here, my panel. The first question that I see here is from, please do note as well where you're coming from when you're asking the questions, just so we have an appreciation of who the panelists will be answering directly. But the first question that I see here on the chat is that relating to the IT, the one that Dr. Mugambi had already touched on. But there's one question that is here. Is it possible for Mr. Mugambi to provide a link to the stated website where we can observe the FAQ?
Yes. I already provided. So if you check the chat, you will see I've shared a few links, and they'll get you to those documents. You can also read the report. You can read our annual reports, what we do as a society, and some of the reports that we've done. We also did a report on analyzing the determination by the data commissioner in 2024. So that should make some good reading. It provides the trends, what kind of cases were, what kind of complaints mostly were there. Yeah, so check us out on the link provided.
Yes, the link is already on the chat, audience. Do follow the link and have a wonderful read as well. The other question here is, how can legal professionals be better supported in understanding and valuing the technical components of DPO-related legislation, given their critical role and frequent skepticism? I believe one of the panelists can just take it for us. How can legal professionals be supported in understanding and valuing the technical or IT components of DPO-related legislation, given their critical role and frequent skepticism?
So a lot, I would say that, get in touch with a lot of the organizations that have other privacy professionals, technologists that are part of their membership, who also invite technologists or, IT professionals, and get involved. That those are spaces where you would learn, you will get acclimated with some of the terminology, the things that apply. Don't be afraid or shy. It's not as complicated as it looks. It is just a first time. Like a first time, it might seem a bit difficult, but the more you interact with technology, the more you know about it, the more you know how it applies to your work as a DPO. So, rule of thumb, don't run away from it, run to it. You will get better at it over time.
Don't run away from it, run to it. Olumide, will you want to chip on that as well?
I think this is also speaks to what we said about association. I mean, if you are able to create some platform for DPOs, these are ideas that you can share within the network. People who have done something similar can explain, or both of you or all of you can come together and agree on the best approach to it. Also, you won't underrate the importance of training and retraining. So, I mean, there are many trainings that one can continue. I am also still going to school around data protection. Learning doesn't stop. Even Mugambi, who has a PhD, is still learning as well. So, I mean, there's still a lot to learn in the field, because it keeps emerging, and that's why it is so important. The books written about 3, 4, 5 years ago might not even be so much relevant anymore, because, I mean, there are so many approaches to it. Even as the GDPR, as it is referred to as the global standards, it has its own shortcomings, a whole lot. I mean, GDPR is even going through some process as we speak. So
Yes.
there's always the need for relearning, and there's always the need for training. So, I mean, attending trainings would be important. And also, like I said, collaboration and forming alliances would also be helpful in dealing with these real-time problems.
Indeed, laws are not stagnant. The laws are changing. Even the global standard, which is the GDPR, it is currently going through amendments. So that means that we need to keep ourselves abreast in all these amendments and changes, and also continuous learning. Remember, do click on the links for our foundation courses as well as our practitioner course for you to get more insights, and let us capacitate ourselves to bring more data privacy awareness in Africa. I think this comment was for you, Igxtelle, when you were making mention of your role and what you have done for when it comes to handling minors' data and protection of children's data. There's a comment that says a classic case of how photos of children in villages around Africa are used in some websites or by some organizations seeking financial aid to help the said children from humble backgrounds. I think this was someone who just wanted to ship onto what you were saying earlier. I don't know if you want to also cement it in any way or conclude it in any way.
No, just to add that, yes, that's very, very common, especially, with non-profit organizations who are marketing on their services and using children's images without prior consent. In Cameroon now, the law requires that before a child's image is used for advertising, that they have written consent from their parents. It is a position that most other jurisdictions should have. If yours does not, as a DPO, you can advocate for that all these organizations have written consent from these children's parents on file before they publish their image.
Indeed, indeed. And I think this one will go to my wonderful panelists. All of you, one of you can opt to take it. It says that as a DPO, am I required to send every data protection policy to the Data Protection Commission for review or approval before submitting it to management for implementation?
I'm not even sure there's any data protection authority in Africa that has that manpower and resources to begin to look at all the policies you draft before you send to. No. Once, I mean, you are knowledgeable to a certain extent, you know what should be in your policies and what, except your laws, because the Nigerian Act has certain provisions that require you to either seek the regulator's opinion, especially when you are conducting data protection impact assessment. I mean, you want to seek their opinion on certain risks or certain processing. And even in their guide, they have actually provided for processing activities that require that. So no, you don't have to. Just prepare whatever you need to prepare, and be sure of what you've prepared, and send it to your management for approval. And if you need to review, because all these documents, they are not one-off. You will have to periodically review them. Maybe when something else comes to your mind, or when there is a change in policy, or when there's a regulatory demand, you will still need to periodically look through this documentation. So no, you honestly don't have to send it to your DP.
And
Indeed.
just to
Yes.
add to that, I think this gives a great idea for us as founders of organizations to maybe think about a peer-to-peer review kind of service that we can offer, because a lot of the DPOs as well are starting out their careers. Some of them may not be very confident in, the policy review, drafting and enactment, of policies for their organization. So a peer-to-peer review more than likely will be something that different, and I'm just throwing it out, it's a thought I'm thinking about, that would be something that would be an added benefit to, professionals in this space to gain more confidence in what they're drafting. More to
Indeed. Yes. There was this comment that I saw posted to also read out. It was more on, what we were discussing in relation to our legal profession and as well as IT. Precious says, I think that because we have been just thrust into this cyberspace when we were not prepared in infrastructure and intellect to deal with the challenges it may bring. I don't think our acts and bills will make the structure work without our vigorous inputs as DPOs to bring in not only the legal fact, but have the IT know how that will enable us to blend the two in a way that will work for us. And I think this further solidifies your point, Mugambi, where you mentioned that sometimes as DPO, having the IT capacity, or at least having the IT knowledge, or at least the foundation knowledge, will go a long way in assisting you to be a better DPO within the organization, and also just assisting when it comes to the protection of the personal data that the organization handles. I think also there was another comment that says that I think our legislators are slow and AI and IT are not waiting. I love this comment. I don't know if there's any of you who want to chip in on this one. Do we agree? Do we disagree? What is the way forward so that we wrap it up?
So I usually tell the clients this. There is one thing. So, do you need to wait for legislation for you to protect your organization? I mean, do you need the government to tell you that you need windows, grills, and doors, and you need an alarm system in your house if you live in a high, high volatile, high security incidents area? You do not need. You don't need the government to tell you that. Please protect yourself. So you either protect yourself. So one of the easiest things with all these technologies is that I help organizations and I inform them that we need just to think about, in this organization, how do we develop IT solutions, how do we purchase and procure IT solutions, how do we test them, how do we execute them, how do we use them, because the organization itself, especially if you're doing IT execution in scale, you just need to do your standards yourself. Don't need to wait for the government, because when you're getting data breaches, or for example, you're processing the wrong data, whether it's personal data or other data, you're the one going to suffer. It's not the government. So the, the institution has really to think inwards.
Yes. There is the last question here, and I believe it will go to all of you. It says it's from Churemi. He says, my question is around the sensitive personal data Mr. Olumide mentioned. To what extent do we limit what sensitive personal data will be? It surely can't be wide as we want it to be.
I honestly don't even think it should be limited. The Nigerian legislation does not limit it, so to speak, because it allows the regulator to prescribe other personal data that would fall under that category. Any data that would expose to someone to an higher than usual risk should be termed sensitive. It doesn't have to have, the categories do not have to close. And the way technology grows, um, even data that would not usually be sensitive, they are now sensitive. For example, the telephone number in Nigeria is meant to be sensitive because your telephone number is now attached to your bank account. The fintech now they've revolutionized everything such that you can open a bank account just with your telephone number. So somebody gets your telephone number in Nigeria might actually have access to your biometric data. So they are all interconnected. So honestly, I do not believe that there should be a closed category of data that's sensitive. Even contextually, somebody's name in a certain context can be sensitive data depending on the context. So ordinarily, I don't think it should be closed. And the laws should continue to evolve, and the regulators, especially in Africa, should continue to evolve to prescribe any category of data that that is sensitive or that will unusually expose people to risks or ridicule or discrimination.
Indeed, indeed. And also anyone else to just close it off before we wrap it up?
No word from me. All's been shared.
No.
Thank you. To our wonderful audience, thank you so much for your engagement through the chat. Thank you so much for the questions, and thank you so much for the engagement as well. But just to note, just a few announcements before you leave. And remember, I mentioned that I do have a surprise for you. And let me just start off with a surprise. Now, the surprise is that our second and third run-ups for the poll are also going to get drums roll, right? They're also going to get, redeem their pass to be part of the course that, our first runner, which is Princess, has won. So do send us an email to info@dpoafrica.net and redeem your prize or your pass. And then let's see you there. Go the DPF July cohort course. And I look forward to seeing you there, and congratulations once again. Now, to get on to the announcements that we have for you. The first announcement is that the Data Protection Foundation course begins on the 2nd of July, and it will be running for 3 days. So do email us immediately at info@dpoafrica.net. We will share the email on the chat as well. Remember, the critical importance is that as DPOs, we have to have continuous learning. We also have the Data Protection Practitioner course that will be launched on the 17th of June. So let's also register for that. You will see the link as well on the chat and also on the screen there. You can also scan the QR code and go ahead and register. We also have some surveys that we are doing. If you follow our LinkedIn page, we have the Aspire survey. So if you're an aspiring DPO or privacy profession, please scan the QR code that you see on your screen as well as on our LinkedIn page, and complete the survey. This is for collaboration. This is for us to understand how best we can assist each other. There's also a survey this one is for practicing DPOs. So if you're a practicing DPO or a privacy profession, please scan the QR and complete the survey. You will see it on your screen. And also, if you follow our social on LinkedIn, our page, you will note, we always have updates on the two. So do fill in the survey and let us know the challenges, so that we can see how best can we work with each other across Africa. Remember what our panelists say, it's all about collaboration, it's peer-to-peer networking, and we look forward to building a better Africa where privacy is one of the most important rights that we are protecting, especially when it comes to personal data. So just to wrap it up, thank you so much to my wonderful panelists. I did not exaggerate. As you can see, they are the leading voices when it comes to data privacy, data protection in Africa. And I also want to thank you for the time that you have given us, your thoughts, your insights, as well as even extending to sharing us some of the personal cases that you have handled in your respective countries. And continue doing the amazing work that you do. We are inspired, and we look forward to further collaborations in future. To my wonderful audience, you guys have been so resilient, I must say. You have been engaging, and I hope that this will not be the end of our meetings, our webinars. Do look out in our LinkedIn page. We always have some of the webinars, so do register for those, register for the courses, do and complete the surveys, and we look forward to having more enlightening sessions like Harmony just noted in the chat, and we look forward to having more engaging sessions. This is an ongoing discussion, an ongoing debate for some, so it doesn't end here. So from me, Lorato Kgosidiile, I'm just an associate attorney here in Botswana. I look forward as well. Do follow me on LinkedIn as well. I will include my URL, and I look forward to having these engaging conversations with you all. Let's go and be the best data heroes that are needed in the spaces that we are working in. Thank you so much, and I hope that you all will have a wonderful day. If it's night, have a wonderful evening. And from me and my wonderful panelist, thank you.
Thank you. Thank you also, DPO Africa Network. Right. Thanks.
Thank you.